Hi guys, welcome back. Today we're going to be looking at Articles 3 through 7 of the Constitution. We're going to finish this up. And then in our next video, we'll talk about how do we actually make the Constitution law through ratification process. So Article 3 of the Constitution creates the federal court system. Remember, the Founding Fathers were terrified of not having one under the Articles of Confederation. George Washington in particular really feared this. So they wanted to create something that was separate and removed from the people, but didn't really know how to do it. They'd kind of gotten to the point after Articles 1 and 2 where they figured, we'll just let future Congresses figure it out. So Article 3 is very, very short. And all it says is there will be a Supreme Court, which, as you can see in the photo, will be the highest court in the United States. We'll define how you can get in it, and then everybody else figured it out after that. They just didn't want to do it anymore. So the Supreme Court today has 9 justices. You can see in this photo here, there are currently 9 that sit on the Supreme Court. Originally, there were only 4. But in order to become a Supreme Court Chief Justice, you have to be appointed by the President and confirmed by the Senate. There are no requirements to become a federal judge in the Constitution. Today, states require that you be a certified lawyer to be a judge, but other than that, there are no restrictions. And you are appointed for life. Now we're going to take a look at whether or not that's a good thing or a bad thing. But you are appointed by the president for life, confirmed by the Senate. The only way you can be removed is if you resign, die, or are impeached. And that's what's ingrained in the Constitution. And then it said Congress figure out the rest. Now, the Supreme Court, we say the federal courts because there are several. As you can see in this diagram here, there are 3 levels of courts. Right, the Supreme Court, like I said, is the highest court in the land. It has 2 different types of cases that come before it. One is called original jurisdiction. The other is appellate jurisdiction. Original jurisdiction is a case that originally or firstly goes directly to the Supreme Court. It very rarely happens. That involves cases with ambassadors. Anytime a state is being sued, it goes before the federal court. The Supreme Court, or if a public official is involved in the trial, but it rarely happens. The one that happens the most often is the appellate courts, and that means that an appeal has started due to some kind of constitutional or legal issue from a lower court. Right, so these are the courts that are below, and I'm going to take you through that process with this document here. So you're put on trial at the state level or at the federal level, which I'll talk about. And what it does is you work your way up. So if there's some kind of legal issue, the Court of Appeals or your state Supreme Court will handle it. There's a difference between federal and state courts, and that's really the severity of the crime. If you steal from Stop and Shop in Warwick, you're going to go to state trial court. If you commit an act of terrorism, think the Boston Marathon bombing, then you go to federal court. That's obviously a much higher level of crime, and that's here in the green. That is the district court. There are 94 of them around the country. Dzhokhar Tsarnaev in 2013 was tried before District 1, which is all of New England and Puerto Rico. And those are original jurisdiction courts. They go right there. Now, what can happen is if there's some kind of legal proceeding or some kind of miscarriage of justice, then you can file an appeal with your lawyer. And the example that I'll give you occurred in 1972. A man from Arizona was arrested for carjacking and kidnapping. And he was sentenced to jail and was found guilty and sentenced to prison. But was not told that he could have a lawyer present during his police questioning. So when he finally got to court, he appealed right to the state court of appeals. Then it went to the state Supreme Court, and then finally it went to the Supreme Court. Right, it had worked its way up through these courts of appeals. There are 12 of them, and basically they're judges who hear your claim of some kind of legal misfortune that has occurred to you. In this case, went all the way to the Supreme Court. And in 1972, in a very famous Miranda v. Arizona, the Supreme Court determined that police are required to tell you that you have the right to an attorney. Right? So what they can do is they can actually overturn decisions by courts if there's been a miscarriage of justice. The job of the Supreme Court in these kinds of cases is what you see down here. It is the ability to review federal law, review constitutional law, and determine whether or not it has been carried out the way it is supposed to be. Right. So over 5,000 people apply every year. Anywhere from 200 to 700 cases get heard a year, but the Supreme Court only gets to pick the cases they want to hear. And you have to basically convince them why you should be heard before them. And they only deal with cases that are really, really influential. So that one's very important. Roe v. Wade, 1973, right? Their job, as you can see down at the bottom, Chief Justice Oliver Wendell Holmes said, the Constitution is what the Supreme Court says it is. Their job is to interpret the Constitution and determine whether or not actions that have occurred fall within the realms of what the founding fathers wanted. And we call that power judicial review. They have the power to interpret the Constitution, and they can actually deem an act of the president or an act of Congress to be unconstitutional. And that's an incredible power. Now, they cannot actively go out and say things are unconstitutional. If President Trump does something, they can't say, oh, that's unconstitutional. No, there has to be a lawsuit that comes before them that they choose to hear. So it's a very, very long process. This takes 5, 7, 10 years before a case actually comes before them. But they have the power to almost institute policy, as they did in Miranda v. Arizona. Now, police officers are required to provide Miranda rights, which if you've listened to Law and Order, you've heard hundreds of times. So it's a really, really incredible power on their part. And we'll talk more about them in the future. There's very little on them in the Constitution. Articles 4 through 7 are much shorter. Article 4 has to do with relationships with states, that you have to protect and respect the act of a state. So if you have a driver's license in Rhode Island, it's valid somewhere else. Right? Article 5 talks about amending the Constitution. This is really important. Let's say we forgot something or we want to add something later on. We have two methods of addressing that. And that's amending things and adding them to the Constitution. The first one is the congressional method, which is how every single amendment except one has happened. And basically Congress writes up an amendment. It's approved by 2/3 of both houses. And then it gets sent to the states for ratification. So this isn't just a federal thing. This is a federal and state involvement, and 3/4 of the states need to ratify it. Now that's really hard to get 75% of the states. That's why we've only had 27 of them. The next one, the 21st Amendment, is when the states propose the idea and then send it to Congress to be enacted. That happened with repealing prohibition. It's something that's only happened that one time. Article 6 is really important. It establishes what's called the supremacy clause, right? And the idea that the Constitution is the supreme law of the land. It is what governs the United States. Everything else falls below that. States are allowed to pass their own laws. That's totally fine. That's part of federalism, but they cannot violate constitutional law. Even federal laws cannot go in contrast with state government. Now, we're going to talk about, there are things that definitely do. Marijuana laws are very conflicting. We're going to talk about later how that works. And then Article 7 deals with actually ratifying the Constitution. How are we going to put this in place? Just because it gets signed and it was created doesn't mean it's law. It would be sent to each of the states, and 2/3 of the states had to approve it. They would have their own conventions. So you need 9 of 13 states to approve it. Once they did this, once they wrote these 7 articles, all the founding fathers signed it, except for 3. Edmund Randolph, who was the creator of the Connecticut Compromise, of the Attorney General, didn't like this idea. And George Mason hated it. George Mason from Virginia would rather cut off his left hand, he said, than sign it without a Bill of Rights, which was a protection of individual rights that we'll talk about, that James Madison will solve. As they were leaving that day, September 17th, Ben Franklin ran into a woman. She asked, well, doctor, what kind of government do we have? And really showing how republicanism is so important here. He said, a republic, madam, if you can keep it, meaning if the people can maintain this government they've created. And of course, they had to celebrate, so they went to City Tavern afterwards, which is the same place that they celebrated after signing the Declaration of Independence. Our next topic is going to be ratification. Do the states actually support this? And we're going to see that Rhode Island in particular really held up ratification.